Continuing our conversation now on the application of drillers' muds, we turn to our ag lawyer, Shannon Ferrell. Shannon, let's talk about these. It's pretty important to have an actual written contract in place, signed, T's crossed, I's dotted before you get started.
Well, absolutely, because if application is done right, and according to the regulations, it really shouldn't cause that many problems. But the problem that we do have is that there are some disreputable applicators out there. There's some people that don't know or don't follow the regulations. And so you need the written agreement to make sure that both the parties are on the same page about how you're going to go about applying this fluid to the landowner's property.
All right, let's talk about the mud itself. What can you actually specify in that contract about the mud being applied?
Well, of course, one thing that I would always try to include in agreements is make it explicit that the applicator is going to follow all of the applicable Oklahoma Corporation Commission regulations, but the regulations are fairly limited, and there may be more that you want to know about the fluid than is required by the regulations. I'll give you an example. The regulations only require that mud be tested for its electrical conductivity, which basically is a measure of how saline it is, and total petroleum hydrocarbons, or you'll hear that called TPH, or total oil and grease. That's basically a measure of how many hydrocarbons are actually in the fluid. But beyond that, there's no requirement for testing. So if you want to know more as the landowner about things like heavy metals, radioactivity, any of those issues, you need to specify in the agreement that the applicator is going to provide you that analysis before the application, because it's not required by the rules.
Okay. Let's talk about where this mud can actually be applied. What are the restrictions there?
The regulations have certain restrictions about application distances from things like water bodies, water wells, property boundaries, and things of that sort, but that's it. So if there are other areas that you want them to stay away from, you need to specify that for them in two ways. Number one, make sure that's written into the agreement, and number two, get an aerial photograph, for example, from NRCS, and actually indicate on that map, I do want application here, I don't want application here. So you might have setbacks from things like your house, your barn, wildlife habitat that you're trying to protect for hunting purposes. Make it as easy as possible for the applicator to stay away from those areas by giving them a visual.
How do we deal with existing tenants in the contract?
We've gotten a lot of questions like that at OSU, because landlords are the ones that are being applied because they're the ones that are typically in the land records. And so sometimes the landlords will allow application without thinking about the implications that has for their tenant. And as a matter of fact, there's probably pretty good legal grounds to say it's illegal for you to allow that if you have a tenant in possession of your property without getting their permission in advance. So two ways of doing that. Number one, you can approach your tenant and say, hey, we're thinking about this. Let's all get at the table and negotiate this land application agreement together. Or proactively, the next time that you have a written lease with your tenant, address that within the lease and say either we're not going to apply fluid to the properties that are being leased, or if we do have application, here's how we're going to compensate both the tenant and the landowner.
What does land application do towards crop insurance?
Well, from talking to several crop insurance providers, what we found is that in almost all circumstances, if you apply drilling fluid to a growing crop, that's going to void your policy for that year. So you will lose your coverage for that year. There's a lot more disagreement, though, about the impacts going forward from that. If you apply the fluid and it does cause a loss in yield, obviously that's going to affect the yield calculations that determine your recovery under the insurance policies. But the insurance industry is kind of trying to catch up to this, because this is, has blossomed so quickly. The policies haven't quite caught up to it yet. So in the next few years, I think we'll see policies address in broader detail what you can and can't do with respect to insured lands.
All right, now last thing, and I guess the happiest part of this conversation for producers, how do we get paid? And how do we put that in the contract?
Because most people don't do this for fun. They do it because they actually expect to get paid.
Right.
So you need to specify in the contract how much you're going to be paid. And in most cases in Oklahoma, that's based on a volume basis. In other words, how many barrels of fluid are applied to the property. That's how the landowner is going to be paid. So make sure that's specified. How you're going to get paid. What happens if you don't get paid? What procedures can you follow to get interest for the delay in the payment?
All right, good information as always. Shannon Ferrell, the Ag Law Specialist here at Oklahoma State University.